Good afternoon, everybody, and thank you for joining us. My name is Teresa Rusnick. I'm a labor and employment attorney here at Bond, Schoeneck King, and I am joined by my colleague, Kristen Smith. She is also a labor attorney at Bond, Schoeneck King. Kristen sits in the Syracuse office. I sit in the Rochester office, but we're available to help employers statewide. We are going to be talking today about an update on New York State's proposed revisions to its model sexual harassment prevention policy. And Kristen's going to give a quick recap on how we came to be exactly where we are. A couple of housekeeping matters before we get into that. If you could please place your questions in the Q&A using that button at the bottom of your screens, that would be great. We will try to take questions throughout and at the end as time allows. And then there will be a survey at the end of the presentation. If you could take a couple of minutes and fill that out, that would be very helpful to us. So with that, I'm going to turn it over to Kristen.
Thank you so much, Teresa. So before we get into the meat of the presentation, which is going over some of the significant changes in the proposed revisions from the state, we thought it would be important to give you some background of how we got here very quickly. If you could advance that, Kathy. So just to give you a recap, it's been a busy few years in New York State in the law pertaining to sexual harassment. It was back in 2018, now 5 years ago, hard to believe, that the state started making all of these changes, including the law that requires you as the employer to conduct annual harassment training and also to develop develop the sexual harassment prevention policy that met the requirements of this law. So this was labor law 201G that was passed in 2018. You'll see on the slide here, we do have a little link here, a plug for Bond's own training program. We do offer a training program that's fully compliant, interactive with state law, and that continues to be a very popular product that we have. And next slide, please. So these changes in 2018 were really just the start. A year later, in 2019, there was a law passed that included a lot of changes, including a very, very significant one to the standard by which sexual harassment is measured in New York State. And I should say not just sexual harassment, but all forms of harassment. So whereas on the second bullet here, you saw the standard used to be that workplace harassment had to rise to the level of being severe or pervasive to be actionable. And that's still the federal standard. In New York, the bar was lowered significantly. And we have this new standard now that we've been living with for a few years. The standard is, it's harassment if you subject an employee to inferior terms, conditions, or privileges of employment. And if you hear training from us or go to seminars about this, you'll hear that the term trivial inconvenience or petty slight, that's an affirmative defense. If the conduct doesn't rise to more than a petty slight or trivial inconvenience, it's not actionable. But what's notable here is this standard came out after the model policy in 2018. So there's probably a lot of policies that don't address this. We'll get into that a little bit more. Kathy, if you could advance. So also in 2019, the New York human rights law was expanded to include all employers. So even employers with 2 or 3 employees became covered. And the statute of limitations was extended for sexual harassment from 1 to 3 years. None of this is new, but it all sort of explains there's been a lot that's happened since the time that you first put your mandatory policy into place in 2018. Next one. Now, that brings us to today. The law that required you to have a policy was actually, although it was passed in 2018, it was amended in 2019 to require the Department of Labor to revisit it every 4 years in consultation with the Division of Human Rights. And this amendment actually said it had to happen in 2022 and then every 4 years thereafter. So that's what the Department of Labor has done. And they're a little bit late on their deadline. They didn't release their proposed model until just this January of 2023, but that's what they've done. And it does have a 30-day comment period that we have a few more days left of. Who knows what they will do with these comments? We don't know how significant if they take them into account, if they make any changes, but that comment period is still open for a few more days. If you hear something today and you think as an employer, it's important for the state to hear your perspective and when considering what this final policy should look like, you have a few more days to do that. So I'll turn it over to Teresa now, who's going to start us off walking through some of the more significant changes. I would note that the changes are significant. This went from an 8-page model to a 13-page model, and so there's a lot more words in it. And we're not going to cover every single new word that's in the proposal today, but we'll hit the big ones. So Teresa.
All right, next slide, please, Kathy. All right, so to kick us off, one of the big changes or bigger changes that we saw in the new proposed model policy is a renewed emphasis on gender diversity. If you recall the current model policy or the original model policy, it mentioned that gender identity discrimination is, in fact, a type of sexual harassment and a type of illegal discrimination. The revised policy expands upon that pretty significantly to say that discrimination based on sex stereotypes, gender expression, and perceived identity are all forms of sexual harassment. It then goes on to define some of the more common terms that we see in the space of gender diversity and gender identity. And those are the terms of cisgender person, non-binary person, and transgender person. And I know from doing this training that different folks have different terms that they like to use to describe themselves and different definitions that they subscribe to such terms. I'm simply providing the terms that the Division of Human Rights has given us in their model policy. So this is what they have set forth as their definition of a cisgender person, which is someone whose gender aligns with the sex they were assigned at birth. Their definition for a non-binary person is someone who does not identify exclusively as a man or a woman. They might identify as both, somewhere in between, or completely outside the gender binary. And then their definition for a transgender person is someone whose gender is different from the sex they were assigned at birth. So we see with the inclusion of these explicit definitions that the Division of Human Rights is putting a renewed emphasis on gender diversity in such a way that it wants to make sure that your employees are aware that gender identity discrimination is a type of sexual harassment and a type of prohibited conduct under the New York State human rights law. So to the extent that you and your workplaces think that your employees, and maybe particularly your supervisors, need to increase their comfort level with these terms and what it means to discriminate against someone based on their gender identity or gender expression, which are both additional categories under the protection of the New York State human rights law, this would be your cue to brush up on that training or do that additional research that's needed in your workplace. Next slide, please. There is also an addition of inclusion of different examples of sex stereotyping in the model policy. So these are types of things that the Division of Human Rights has pointed out in its revised model policy and said, these are the things that we consider sex stereotyping, which is a type of sexual harassment. So things like remarks regarding an employee's gender expression, such as wearing a garment typically associated with a different gender identity, asking employees to take on traditionally gendered roles, such as asking a woman to serve meeting refreshments when it is not part of or appropriate to her job duties, intentional misuse of an individual's preferred pronouns, creating different expectations for individuals based on their perceived identities. And as an example of that, the division lists dress codes that place more emphasis on women's attire and or leaving parents or caregivers out of meetings. So these are all examples of conduct that the Division of Human Rights has looked at and put into its policy and said, these are examples of sex stereotyping. These are examples of harassment. I do want to call out one or two of these in particular. First one being the intentional misuse of an individual's preferred pronouns, or as we sometimes refer to it, their correct pronouns. The preferred pronoun language has somewhat fallen out of favor, but it is the phrase that the division uses in its model policy. In any case, this is a trend that we've been seeing here at Bond at the Division of Human Rights for a number of years. People have been making administrative complaints saying that they have been referred to by their incorrect pronouns, and there was an open question of whether or not the division would consider that to be harassment in and of itself, and resoundingly, we have found that they had, and this is an affirmation of, I think, a larger trend in that area. And then remarks regarding an employee's gender expression or wearing a garment typically associated with a different gender identity. These are another subset or type of remarks that I've seen an increasing number of, things like real men don't dress that way, or real women don't wear their hair like that, or comments like that, all of which the division is now signaling are going to be types of prohibited harassment, at least in their view. And we'll talk more about that in a couple of slides. So Kristen, back to you. Next slide, please, Kathy.
Thank you, Teresa. Couple things, I'm watching the questions when I'm not speaking. Lots of people are asking whether we'll be providing the slides, and we will be able to do that. Someone also asked if we could put the link to Bond's training in the Q&A box, and I did that. So now we're going to get to sort of the takeaways at this end of this presentation. But in order for what I'm about to say to make sense, I should say that the division does not require employers to adopt this model policy word for word. The extent to which you must adopt it is open to somewhat debate, but there is an opportunity to customize the policy to suit your workplace, and that it's a question of risk tolerance of how far you want to stray from the model policy. That being said, I want to talk about a new section of the model policy that's been proposed, which is it's not really a new section, but in the retaliation section, the division offers a list of examples. And the original model policy did not have any examples when it came to retaliation. And, I do think examples are a good idea. I think they tend to bring the conduct to life for employees, and it makes it easier for them to understand what we're talking about here rather than bland legal phrases. I have here on the slide the examples that are included for retaliation in this proposed model. And they start out being pretty straightforward. I think things that we would all agree would constitute adverse employment actions if they were taken because an employee engaged in protected activity, which of course is making a complaint or participating in an investigation about a complaint. So things like demotion, termination, reduced hours, things like that. The second one is publicly releasing personnel files, kind of an obscure thing in my opinion, but there was actually an amendment to the law passed in the past couple of years that said that releasing someone's personnel file in retaliation for their protected activity is an adverse employment action, not something we really see very much. Refusing to provide a reference. This one is something to think about, right? Because I think we see employers that have a lot of policies that don't like to give, you say, we'll just give dates of employment. So to say that refusing to do one is retaliation is kind of questionable. Disparaging someone on social media. We do see a theme throughout the revised policy, more references to social media and virtual platforms. Labeling an employee as difficult and excluding from projects. Now, when we're getting down to some of these bottom examples, they become a little bit more sort of open to interpretation and perhaps misunderstanding. So these are the bullets that if it were me giving advice, I'd really look at these very carefully and whether they fit in properly in your policy. But you should know, though, as an employer, that the division views these things as potential adverse employment actions, labeling an employee as difficult, excluding them from projects, undermining an individual's immigration status. Certainly that would be adverse to someone. But finally, reducing work responsibilities, passing over for a promotion or moving an individual's desk. Certainly, not promoting someone is well known to be an adverse action. And so in some cases, reducing responsibilities as well. But I want to take a pause to note this last one, moving an individual's desk. We're talking about a spectrum of adverse employment actions. To me, this one's pretty far away, from the top one, which would be a termination. And I want to note here, this really caught Teresa's attention. Sorry for speaking for you, but Teresa had this case in federal court just last year and, made the argument that moving someone's desk in and of itself is not an adverse employment action. It's not actionable. Teresa won that case. So at least in the views of the federal court, moving someone's desk is not necessarily an adverse employment action. So it's questionable whether it's something you want to put in a policy. And even just yesterday, I got that question from a client. They wanted to move someone's desk. So it comes up more than you think. So, look closely at these examples and, and determine what you'd want to include. And let's move to the next one, the next slide. The original model policy did have examples of harassment. This revised model adds a few that are worth noting. One is a focus on the service industry. So if you are in the service industry, this is probably a good idea to point out to your employees that conduct from your customers or your clients can constitute sexual harassment. I think you want employees to know that they have a place to turn when that kind of conduct from third parties occurs. So there's some good language about that in the revised policy. There's an expansion of I would say the type of conduct that is described as harassing to include romantic things, questions or comments about a person's romantic history. In the earlier policy, it didn't have questions, it just said comments, but I think we would agree questions can be equally problematic. But previously it talked about comments about a person's sexuality or sexual experience, and that's the kind of stuff we traditionally think about when we train on sexual harassment, but really, any training I've ever done, I'm talking to employees about how you don't want to come anywhere close to the line of what can be considered harassing. And those discussions about romantic partners, do you have a boyfriend, that kind of thing, while on one hand might be, really benign, could lead to, an uncomfortable situation and something you probably want to be training your employees to avoid. And so might want to think about whether you want to, amp up that language in your policy. And it also mentions repeated requests for dates or romantic gestures, including gift giving. So those are some new examples. Another thing is this emphasis on the idea that, harassment comes in many shapes and sizes and forms. And so the policy has a lot of new language that emphasizes that for employees. And here's a quote: any employee who believes they have experienced sexual harassment, even if it does not appear on this list, should be encouraged to report it. And there's even bold language in the revision that says, this list is just a sample of behaviors and should not be considered exhaustive. I really like this line, and hopefully your policy already has something like this, because I think as an employer who's trying to enforce your policy, when you find conduct that occurs that you don't want to tolerate in your workplace, but maybe it's not listed in your examples, you want to be able to point to language like that that says, this list is not the end all be all. So some good stuff in there on this topic. And next thing that we're going to cover, Teresa's going to take it from here and talk about, next slide, remind me, bystander intervention.
All right, so in addition to the changes we've already discussed, the revised policy has a new section on bystander intervention. So what essentially happens if you witness harassment, and what employees are supposed to do if they witness harassment, or some suggestions for them anyway. So it starts off by noting what I think should be common knowledge, that supervisors who are bystanders need to report the harassment. So even if your supervisor isn't directly engaged, even if they don't necessarily maybe supervise the employees who are engaged in the harassment, they still need to report it. They still have an obligation as a supervisor to undertake that mandatory reporting. And Kristen's going to talk more about supervisory responsibilities in a couple of minutes. But for your other employees, the new model policy provides 5 standard methods, their language, for intervention for bystanders. And so the first of those is to interrupt and distract. The second is to ask a third party to interrupt and distract. The third is to record or take notes of the harassment. The fourth is to check in with the person who has been harassed. And then finally, the fifth option is to confront the harasser and call out the behavior as inappropriate, with the caveat only if the bystander feels safe to do so. I would add with the caveat only if the bystander wishes to do so or feels comfortable doing so. In addition to feeling safe, there's not that level of mandatory reporting that we see with non-supervisory employees that we see with supervisors. Certainly, we would want to encourage them to report, but we also don't want them to feel harassed themselves by intervening in the situation. I will say, of these 5 standard methods for intervention, it's the third one, particularly the use of the word record, that made me kind of perk my ears up a little bit more. This suggests that the division is encouraging employees to take out their smartphones and record harassment as it's happening in the workplace. I'm not sure that that's necessarily something all employers would want to encourage, particularly employers who work with sensitive information or patient care information. So if you're going to include that language in your revised policy, I suggest that you think about that and perhaps include some caveats as well. Next slide, please. The other thing that the revised policy does that I thought was really important, and I think it speaks to a broader trend that we've seen at the division and even in court over the past couple of years, is this emphasis on the impact of actions rather than the intent of the person who took the actions or made the statements. And the division gives us an example. The intent of the behavior, like making a joke, doesn't neutralize a harassment claim. the revised policy clarifies that not intending to harass someone is not a defense, and the impact of the behavior on the person experiencing it is what counts. I think this is an important point to emphasize to employees when discussing the effect their actions could have. Kristen and I and several of our colleagues undertake harassment investigations, discrimination investigations routinely. At any given time, we have half a dozen going on apiece. And this is something I continue to see people use as a defense, quote unquote, for their conduct, which is that I was just kidding. I hug everyone. I didn't mean to harass her. She took it the wrong way. Those types of things that people still seem to think justify or excuse their conduct. And that's really not the case anymore. And that is something I think the division is right to put an emphasis on in this revised policy. When you're talking about intent and impact, you really want to be looking at the impact that that action had on the person who experienced it from the lens of a quote unquote reasonable person, and how a reasonable person in that situation would have reacted or would have had the same impact on that reasonable person. So again, when you're doing your trainings, when you're rewriting your policies, I think it's important to emphasize to your employees, you may not intend any harm. You may be kidding. You may think it's funny. You may just be speaking off the cuff, as it were, but that is not necessarily going to carry the day or be any kind of a defense when push comes to shove and you're in front of an administrative agency or even a court. So I'm going to turn it over to Kristen to talk about remote workers. Kathy, if we could have the next slide.
So another change we see is this new recognition of our new workplaces, right? There's such a normalization now of remote work that didn't exist in 2018. And so you see references sprinkled throughout the new policy about how harassment can occur in a remote setting. And I think this is another really helpful addition from the division, because I think we would have understood this to be the case already, that this harassment can occur even if you're not physically in the same place. So there are examples throughout. And here's a quote here: harassment can happen on virtual meeting platforms, in messaging apps, or after work hours between personal cell phones. So, that's something you would want to also incorporate into your training if you're revising your training. Also an interesting one, posters and other materials in the background of virtual platforms. So if I had something offensive behind me here, that would be something that could impact someone in the workplace. So there's a recognition of that in the new policy. And, this isn't really a new section, but it's just referenced throughout. Next slide. A change that you may already have in your policy, if you've been updating it regularly, is the addition of the state's new sexual harassment prevention hotline. This is something that was established within the last couple of years and came online just in 2022, if my memory serves me correctly. It has the creative fitting number of 1-800-HARASS-3, but you're required to put this in your policy. While we talked earlier about, maybe not needing to include every single word of this revision in your policy, this is one that we would say you need to include. This is a volunteer hotline that's available for employees to call if they think that they've been subject to harassment or discrimination, and they can get some free advice. Another thing that I found interesting was, this is a kind of a small wording change, but in the section where it talks about employees' external remedies, meaning that the ability to go to the Division of Human Rights with a complaint or go to the EEOC, and you are required to have that part in your policy. They added something in the section about the division's complaint process, where they said the website has a digital complaint process that can be completed on your computer or mobile device from start to finish. I don't know that I was fully aware of that. And, previously you did have to print out a form and have it notarized and send it in. And that, in fact, the original model policy says that. So employees now can just go online, go on their phone and submit an app. I don't really know how it works with the getting it notarized. I think that employees still need to swear their, have their swear to the truth of their complaint. So didn't have a chance to sort that out, but I just thought that was an interesting addition of language, and just another area where if you're going to be revising your policy, kind of consider, whether you need to include that line or not. I don't think it's mandatory. Next slide. Oh, we're gonna change gears here again. We're going back to Teresa.
Okay, so one of the things that I thought was interesting, and this is really throughout the revised model policy or the proposed revised model policy, that I thought was interesting is even though this is a sexual harassment based policy, the division has placed a renewed emphasis on different types of harassment and discrimination as well. And so it includes at the very beginning of the revised policy a list of all the different types of protected categories under the New York State human rights law. And most of these are things that you're probably familiar with, things like race, creed, color, national origin, disability, things of that nature. And indeed, that list is even a little bit incomplete now because I think since the division wrote this policy, they've added 2 more protected categories of citizenship and immigration status as well. But it goes to show that it's an ever expanding list, and it goes to show that the division is saying that these types of things are also illegal. We want your employees to know about them, and we think prevention policies outlined in this policy, the sexual harassment policy, should be considered applicable to all protected classes. Now, they don't give examples, of types of race retaliation or types of disability discrimination the same way they do with sexual harassment, but you do see this language throughout where they talk about this policy and the prevention strategies and parts outlined herein should be applied to all protected classes, not just sexual harassment. And that is a bit of a change from the original model policy. Next slide, please. In addition, there's quite a bit of new language about how different identities impact an employee's understanding of the world and how others perceive them. The division spends some time discussing how an individual's race, abilities, or immigration status may impact their experiences with gender discrimination in the workplace, and again repeats that the methods for reporting and investigation discrimination based on other protected identities are the same. Now, that's in the division's view that you should be applying the same level of scrutiny and zealousness to your investigations of any type of discrimination or harassment, just the same way that you would be for sexual harassment. So in light of that, this is a trend Bond has kind of been on top of for some time. In light of that, we do have a model policy that we've developed here that integrates all types of discrimination and harassment into this sexual harassment policy, and allows employers to provide the same investigatory procedures to all types of different protected categories, discrimination and harassment. So that's certainly something that the division has placed a renewed emphasis on here, and that we've also seen in our own practice as well. Next slide, please. Interestingly, the division emphasizes this point of individuals bringing their personal history and their other types of identity with them to the workplace, and views that as a lens by which people may understand the behavior that occurs around them or the statements that are made to them. The division is placing a new emphasis on how important it is for employees to be aware of how their words or actions may impact someone with a different experience than their own in the interest of creating a safe and equitable workplace. So I think this is all very interesting. I think this goes to a little bit of what I was saying earlier about the impact versus intent debate. And this is the division saying that different things may have a different impact on different people based on their backgrounds and individual unique experiences, which, by the way, may cross into other types of protected categories such as age, race, national origin, etc. Next slide. The division then gives examples of ways in which other types of discrimination may interact with sexual harassment. And so it says things to the effect of placing different demands or expectations on Black women employees than white women employees can be both racial and gender discrimination. An individual's immigration status may lead to perceptions of vulnerability and increased concerns around illegal retaliation for reporting sexual harassment, or past experiences as a survivor of domestic or sexual violence may lead an individual to feel re-traumatized by someone's behaviors in the workplace. So this, I think, shows that the division is recognizing that people do not come at things with a single lens, and that people who may feel harassed based on their sex or gender identity may feel particularly, traumatized or stigmatized based on their past life experiences. And this is drawing an emphasis to that for employers to be aware of. I think this speaks to a level of attention and concern employers are going to have when conducting investigations. Or, if you're engaging with a third party to do investigations, the level of attention and concern they're going to have to some of the different intersectionality issues at play here. So Kristen's going to talk a little bit more about that on the investigation side of things. But before she gets to that, I'm going to turn it back over to her.
Hi, another new emphasis in the revision is the responsibilities of supervisors. And the model policy actually uses the term special responsibility. And I put this quote here, leadership matters, because it caught my attention. In the section about reporting, it starts out by saying, everyone must work toward preventing sexual harassment, but leadership matters. And then it says supervisors and managers have a special responsibility to make sure that employees feel safe at work and that the workplaces are free from harassment and discrimination. So I thought it was interesting because I think that's something that when we've done training on harassment for supervisors and managers, something that we really try to emphasize that, having a culture where those in leadership really pay attention to these issues is important. And so it looks like this, this policy is reflecting that concept, and probably a concept that you on the webinar, lots of HR professionals appreciate as well. You're probably preaching that to your leaders as well. So yes, certainly a much stronger emphasis. There's repeated references throughout the new model, the revised model, about the heightened responsibility that supervisors have to report. And it makes the point that they shouldn't be passive. So it's not just managers, when you receive a report of discrimination, make sure you pass it on. It takes it a step further in here and saying, you shouldn't just be passive and wait for someone to come with you. If you observe it yourself, you should be bringing it forward. And again, you're seeing sort of this theme that we talked about earlier, bystander intervention, that of course would apply to supervisors as well. And then you get this concept that ties into what Teresa was just talking about, is about the traumatic impact of harassment. I think I'm trying to keep an eye on the questions. There's a gazillion. And, someone did ask, are there things in here that aren't in the state human rights law? It's sort of a tough question because, there's so much color, I guess you would say, around this policy, and takes things further in terms of in various ways. But this one struck me as talking about how supervisors should be mindful that being identified as a possible victim of harassment and being questioned could be re-traumatizing. True, right? Very well could be. And good idea to train your supervisors to be sensitive when you're conducting an investigation, or even when you're intaking a complaint from somebody who comes to you, training those supervisors to have those soft skills. But, does the human rights law talk about, sort of the trauma associated with harassment? No, it doesn't, there's no sort of special sort of cause of action or something like that. But I don't know, I just think it's interesting how you see sort of concepts that we talk about a lot in society today in other settings, and, higher ed, things like that are coming now into this model policy. Another thing I would note here, supervisors and managers must accommodate the needs of individuals who have experienced harassment to ensure the workplace is safe. And the word accommodate jumped off the page to me, because I do worry a little bit that word has a very specific meaning in the world of employment law to relate to disability, reasonable accommodations for disabilities, and is the division suggesting there's some sort of heightened accommodation requirement for those who complain? That doesn't exist in the law, but certainly we always advise that you take interim measures when you're dealing with those who complain about harassment, to make sure that you're putting an end to any potential conduct. But to use the word accommodate might create some confusion, is all I'm saying on this point. So just sort of interesting word choices throughout the model. If you could flip to the next slide. This is again more of the same. There's this emphasis on victim trauma when it talks about the investigation process, and there's language that says here that the company or whoever is employing this policy recognizes that participating in a harassment investigation can be uncomfortable and has the potential to re-traumatize an employee. Therefore, those receiving claims and leading investigations will handle the complaints and questions with sensitivity. And so a lot of takeaways here, right? Good training for those who are collecting complaints, receiving complaints, training for those who are conducting investigations, being sensitive to these issues, because it will be interesting to see if, the division starts getting into the business of investigating your investigation, right? So were you creating an additional, hostile work environment or engaging in retaliation because you weren't particularly sensitive to the victim? We haven't seen that, but is that the future? Maybe this is a preview. We don't know. Next slide. All right, so that brings us to, we've got about 7 more minutes here, kind of to wrap things up here and kind of give the takeaways. I'll turn it over to Teresa, and then we can see if we can get to some questions.
Okay, great. So, here's the big question. What should employers do? And this is one I think I've seen in the Q&A more than once over the past half hour. So here's what the policy says employers need to do. The revised model policy says employers are encouraged to tailor this policy to their individual needs, which is good. As Kristen mentioned, there is some room for you to tailor this to your needs, but it also warns that no section in this policy should be omitted. And to me, and I think to Kristen, this is a little bit vague. Does it mean that you can have a section on remote workers and change up the content a little bit? But you can't entirely omit the section on remote workers. Same thing for bystander intervention, gender diversity, all the different categories that we talked about, and then the question is, when exactly do employers have to adopt this new language? As we mentioned at the very beginning, the public comment period closes in just a few days on February 11th. Because this is being done outside the usual regulatory structure, it is not clear when or if the division is going to take these comments into account and issue a revised model policy for our final consideration and use. I would hope that would be within a few weeks of February 11th, but I really can't say for sure. There's been no timeline suggested that I'm aware of. Some comments may be taken, some comments may not be taken. They may not take any comments at all. So we'll see what the division comes up with. When the final model policy does come out, I'm sure employers will be asking when exactly they're required to adopt it. I haven't seen any deadlines published by the division as of yet, and I'm not entirely sure that they will publish a deadline. They may just say, this is the new model policy. This is consistent with our guidance. You need to adopt it, employers. Those are just kind of my thoughts, more speculation than anything, because we simply don't have the level of information I wish we could give you on this. But certainly I would expect within the next couple of weeks to the next month or so that we are going to see a finalized model policy, and that there will be some obligation on you on the part of the division to make the changes that they have made. So Kristen, anything you wanted to add to that particular point?
Yeah, I think just to say, there's arguments that could be made that that everything that you would have had in your policy in 2018 is still what the law requires, except for the few things that we mentioned: gender identity, the 800 number, a few things that actually have changed in the law, and that a lot of this is more best practice and bringing it into line to how the division would view something in the event you end up before them in an investigation. So I think there's sort of this continuum of risk tolerance for employers. The safest thing to do is always to use the words of the state, right? Because that they're not going to have a problem with that. Then on the other end of that continuum is, I'm going to do sort of the basic and, keep it succinct. This is too much, and there's risks, of getting too far from that. But what I don't want you to walk away from is saying, okay, this is our new policy 100%. That's not what we're saying here. This is a model, and that's why they use the word model. And they specifically say that you can make changes. So that's what I would say. The other thing is in terms of timing, a lot of people have asked that in the chat. Teresa said we don't really know, but to me, if you roll this out, if you're doing annual training, say in the fall, and you roll it out the same time as the training, I don't think there's going to be a requirement that you instantly change your policies. I mean, it's a process that you have to go through, but you might want to get started now thinking about sort of how the rollout would work. All right. Do you see any good questions? Or they're all good questions. Sorry. Do you see any questions that we have time to get to there, Teresa?
Yeah, so one I saw that's been asked a couple of times is, will the state be updating its model training? For those of you that know, the state has released a model training in conjunction with its model policy. So far, it's only updated the policy. Will it update the training? I would expect so, to be consistent with the policy. I think the state would want the policy and the training to be consistent. Now, can I say that officially? No, I haven't heard anything to that effect. I don't know when that might happen. I'm not sure that the state even has that on their agenda, to be honest with you, but I think it's certainly a possibility. And kind of in conjunction with that, should you update your trainings, for these policy changes? Are there things that if you change your policy, should you change your training? And I think the answer to that is yes. To the extent that you're including new things in your policy, for example, gender diversity. And, in your training, you've never done an emphasis on gender diversity. And maybe your employees don't know what some of these terms mean or how gender identity can impact the workplace. That may be a great thing to put in your training. Some of the other things that Kristen mentioned that you may want to de-emphasize or not include, obviously, if they're not in your policy, probably really wouldn't put them in your training. So those were two questions that I saw a lot. Kristen, anything you wanted to get at?
Yeah, we just had someone, one question is whether you have to retrain employees that have already completed the training this year. I don't think so. No.
I'm not reading anything to say that would be the case.
No. If we use bonds training, will that be updated? We're talking about that right now. We've been discussing this model and how we might, we do refresh it regularly. So I do anticipate there will be a refresh that does incorporate some of these concepts. I don't have a time frame for you on that.
I saw one person ask what I thought was an excellent question, particularly excellent question, about Governor Hochul's proposal that all training for sexual harassment be conducted in person. For those of you that cast your minds back, that was one of her original proposals when she became governor. It was in her initial acceptance speech, as you will. I have not seen anything else to that effect, but please rest assured that is something I watch extremely closely, because that would be a pretty big sea change in this effect if it were to come down that all of this training needs to be done in person and couldn't be done online or through some other interactive format. So I do understand the concern there, and we certainly are keeping on top of that here at Bond. Kristen, anything else you wanted to answer? Or did you want to just close us out here?
Somebody did mention intersection with Title IX, and we probably have a bunch of higher ed folks here on the line. I would just say there's a lot of concepts in here that you can tell are borrowed from the Title IX world. And unlike the Title IX world, where there's extensive regulations about how the investigations have to occur and concepts like that, this model policy is not sort of grounded in state regulation that has any new requirements with respect to interim measures or the way that sort of an investigation is handled. So no changes really required from a regulatory perspective that would remind you of the higher ed world.
Okay, then I will just note, to answer the most common question asked, you will be getting a copy of the slides as well as a link to this recording in your email from our wonderful marketing coordinator, Kathy Purdy, or someone on her team. You should get that shortly after the webinar concludes. If you go to our webpage and click on events and recordings, you should be able to find it there as well. As an additional reminder, we do have a weekly webinar on Tuesdays at noon, from noon to 12:45, where we discuss all types of legal updates, not just labor and employment. And if you're looking specifically for labor and employment news, please subscribe to our blog. And the addresses for you to do both of those are there. Both, of course, are completely complimentary to our clients and friends. Okay, so Kristen, anything else you wanted to add, or we're a little bit past 12:45
a little over. I just wanted to say thank you, but I also wanted to say there's a lot of good questions in this chat. We're sorry we didn't get to them. We will look at them and we can use those as sort of suggestions for ideas for our weekly webinars.
All right, with that, thank you, everyone. We appreciate your time and attendance today. And of course, we always appreciate you joining us, and we hope to hear from you soon.
Thanks.
Bye-bye.